To be here in this wonderful city of Cairo and also be a partner of this very important project. I've been very impressed with the people I've met here so far, with their enthusiasm and compassion for patient care as well as for research, and I think that's a very good mix for making a successful project out of our LIFE project. I will be talking about forensic services in the UK and point out some of the challenges we face. I'm talking about that because that's a service I happen to know, so that's not by any means to mean that we know it better or the way it's done in the UK should be copied anywhere else. I'm actually not from the UK myself, as you might have figured out from the accent, but I think it's very important that we learn from each other, so I think you can learn from some of the things we do, and we can learn from some of the things you do, and then in the end we have a better service for all of us, for our patients, and also better research. So, just trying to figure out how that works. Yeah. So I say a little bit about the legal system and the Mental Health Act. I hope it's not too dry, but I think it's important to place the service provision in the context of how people get in and out of those services, because that determines to a large extent who you actually find in your services. I'm going to say a little bit about how in the UK quality assurance is done, how services are monitored for the quality of service provision. I say a little bit about service user involvement, which might be unusual to you or maybe not, but I think it's important to involve the people who are receiving the services in their design, and I will say things about opportunities and challenges probably as I go along, but also at the end, and I hope we can then later on in the discussion spend some time to compare good and maybe not so successful things about our services in the UK and here in Egypt. So when I talk about the Mental Health Act and the way services are delivered, I'm talking mainly about England and Wales, because the UK, as you know, consists of various parts, and Scotland and Northern Ireland have somewhat different services. So it's mainly about England and Wales I'm going to talk about. So as you will probably know, in the UK and in England there's a common law system which is based to a large extent on case law, where the law is developed by judges through the decisions of the court, which then provide a precedent for future decisions. So it's less dependent on statutes, but more dependent on case law, which has the advantage of being more fluid and more responsive to changes in societal values, but has the disadvantage that it doesn't really separate the powers and doesn't involve the parliament in the law making, because it's to an extent made by the judges by their judgments of different cases. It's also an adversarial system which has advantages and disadvantages as well, so you have two different sides fighting, bringing their point across, as opposed to having one judge to take all the evidence in and make the decisions. The jury determines the verdict, and then the judge passes the sentence, and the trial will only be conducted if the accused pleads not guilty. Some figures about the UK system, and these are definitely things not to be copied. The age of criminal responsibility is quite low in my view. It's 10 years, which is the lowest within Europe. I know the systems in Europe better than obviously in other parts of the world. I think it's 12 years in Egypt, if my Googling came up with the right figure. 10 years is actually quite low. The incarceration rate in terms of prisoners per 100,000 is amongst the highest in Europe, with 146. It's actually the highest in Northern and Middle and Southern Europe, before Spain, and then other parts of Europe, and particularly the Scandinavian countries have much lower figures of imprisonment. So it is actually a society that places emphasis on punishment and on incarceration. It also is amongst the highest numbers of life sentences and indeterminate sentences within Europe. Again, another thing not necessarily to be copied. So looking now at the legal provision for mentally disordered offenders, this is regulated within the Mental Health Act, not within the criminal law, but actually within the Mental Health Act, which is the same act that governs the detention of non-offending psychiatric patients. And the definition of a mental disorder according to the Mental Health Act in England is any disorder or disability of the mind. So somebody, in order to be incarcerated or detained, whether or not they have offended, has to have a mental disorder, any disorder or disability of the mind, which is a rather loosely defined definition. So it doesn't talk about specific disorders like schizophrenia, it doesn't talk about a specific severity of disorder, but it keeps it quite broad, which has again advantages and disadvantages. It can capture a lot of people who might need treatment. On the other hand, it might capture possibly too many people who might find themselves being detained. There are some exclusions and exceptions. For example, people with learning disability are only considered. What do we do here? Cancel. Oops. Well, it will go away. Potentially. Oh no, it goes away here. Hang on. Yes. Yes. It's okay. Don't worry about it. Right. Okay. So let's hope that doesn't happen every 2 minutes. Okay. Fine. So learning disability is only considered to be a mental disorder if it's of a larger degree of severity associated with aggressive behavior or irresponsible conduct. And dependence on alcohol and drugs is actually excluded. It's not considered a mental disorder within the Mental Health Act in England. Again, this has advantages and disadvantages. It is seen more as a behavioral choice, I guess, of people rather than a disorder, which has the disadvantage that people with mental disorder, with substance misuse disorders, get probably less services than they would otherwise get. They can of course be treated voluntarily, but they couldn't be admitted against their will on the basis of their dependence on alcohol and drugs. So this is what a mental disorder is in English law. Then general criteria for detention, this is for any patient regardless of whether they have offended or not, is that they have a mental disorder, as I just said, which is of a nature and degree that makes it appropriate to receive treatment in hospital. Again, you can see it's rather vague. Some people would say too vague. Nature or degree, that can be anything. It doesn't specify, it has to be particularly severe. It talks about the detention being necessary for the health, safety and protection of others. Again, it doesn't say that the risk towards self or others has to be severe or imminent as it does in other legislations. It does have a provision though that the treatment in hospital should be the last resort, so treatment cannot be provided unless the person is detained, and treatment has to be available in the hospital. This is also important, so the law doesn't allow somebody to be detained and then not be treated. So if somebody is detained for the protection of self or others because of their mental disorder, they have to actually be offered treatment. It doesn't mean that they have to accept the treatment. There are people in hospital who don't accept that they should be treated, but it is made available, and that's important from a human rights perspective, that people aren't just detained for the protection, but are also given treatment that would allow them to improve and then to be discharged again in the future. There's a number of people who have to be involved in making a decision to detain somebody, an approved mental health professional, which is usually a social worker, and 2 doctors. The nearest relative can object and has a voice to some extent, but there is no involvement of the court for somebody who hasn't offended. If somebody has offended, of course, they can be sent to hospital instead of prison, which is a hospital order. and you don't have to read all of those because the criteria are quite similar to non-offending people, except that the judge decides. What is important to point out here is, and this is very different from most other jurisdictions, is that the degree of criminal responsibility plays no role in the decision whether somebody is sent to a forensic hospital or not. So somebody can be detained in a forensic hospital regardless of whether they have criminal responsibility, whether they're insane or not. The decision is purely based on the fact that they have a mental disorder at the time when they are assessed and that they need treatment in hospital. So whether they or not at the time of the crime they were responsible doesn't make a difference. They can even be detained if at the time of the crime they were not mentally disordered, but they become mentally disordered later. They can still be sent to a forensic hospital. And they can also, under prisons, transfer, again this is different to other jurisdictions, they can be sent from prison after they've been sentenced to a prison sentence, and then they might develop a disorder 5 years later. They can then be sent from prison to a forensic hospital later on to be given treatment. And again, this is to some extent positive or an opportunity, because it means that people who are ill in prison are actually given treatment and are sent to hospital. On the other hand, they can then remain in hospital beyond the time of their sentence, so they could be given a 10 years prison sentence and then develop